people.
Appreciate it.
Okay, and one more thing. Okay, this is People of the State of Michigan versus Jonathan Garfield, docket number 20-624FH. This is the time set for sentencing. Mr. Garfield, you were convicted of aggravated possession of child sexually abusive material. That is a felony punishable by up to 10 years in prison. You have the right to be represented by an attorney. You are represented by Mr. Kuntz. And Mr. Kuntz, have you had a chance to go through the pre-sentence report with your client?
Yes, Your Honor, we went through it pretty thoroughly last week.
Very good. Do you have any additions, deletions, or corrections?
We have just a handful of additions, Your Honor, and I have made Ms. Allen aware of each of these.
Okay.
So on page 4 of the narrative portion, under criminal history, in the it's the second entry.
Where they list the criminal history 2 of 2?
Yes.
Got it.
And it's in the notes section.
Yes.
So Jonathan went to Williamston High School a grand total of 3.5 years. It says a half a year and then an additional 3.5. And it also indicates that he liked it there, and that's why he continued to go into Williamston. But there was a little bit more to it than that. It was in his best interest for him to stay in Williamston schools.
Okay, but I changed it to 3.5 years?
Yes.
Okay, got it. And what's your next one?
It's under the employment history. There are actually quite a few additions here, and I don't know how the court would like me to handle this. We have 10 total places of employment.
Oh, I can't add all those.
That's kind of what I thought. I guess.
Do you want to, has the prosecutor seen them or know of them?
Yes, I emailed these to her.
Did you have any issue with that, Ms. Allen?
No, Your Honor.
Then I would suggest you submit them in an email to me, CC Judge Allen, CC Ms. Allen, and then I will incorporate them into the PSI and have it corrected to add those.
Very good. Thank you, Your Honor.
Mm-hmm. Anything else?
On page 7, under health and mental health in particular, it says that at a young age, Jonathan went to Chelsea Family Center for family counseling, but it was in fact individual counseling, and it was just a few years ago in 2017 or thereabouts.
But at Chelsea?
At Chelsea, yes.
Okay, so he reported individual counseling a couple of years ago?
Yeah, 2017 or so.
Okay. Okay, I got that.
And last thing, for finances, it says a liability of attorney's fees, that he does not have any liabilities there.
I crossed it off. That was it?
That's it, Your Honor. Thank you.
Okay, any objection to the scoring of the guidelines?
No, Your Honor, I believe Ms. Allen thinks they should probably be scored under OV12 instead of OV13, and it comes out to the same point total, and
Okay.
I agree.
I'll turn to her then. First, Ms. Allen, any corrections to the report?
No, Your Honor. Thank you.
Okay, and now the guidelines?
Yes, Your Honor. The 25 points under OV13 should be scored under OV12. It's just a switch between, it doesn't change the level or the range.
Got it. It sounded like no objection to that, so we're still at the 15 to 25 months, but I acknowledge the Killebrew of 12 to 20. And that was it for the people's corrections then?
Yes, Your Honor. Thank you.
Okay, did the people wish to be heard?
No, Your Honor. Thank you.
All right, and then Mr. Kuntz.
Thank you, Your Honor. Now, I indicated in my sentencing memorandum that courts have a hard time. Courts have a hard job when it comes to sentencing anybody, particularly in cases like this. because the conduct is, well, it ought to be criminal, it ought to be punished, and we acknowledge that real children were harmed here. At the same time, courts also have to take a look at the defendant as they are as a whole person and how they've come before the court. And I've gotten to know Jonathan over the last, I want to say 9, 10 months, 11 months, I think. And, I've gotten to know somebody who's more than just, what his conviction says he is, what the allegations in this case say he is. And somebody who's kind, thoughtful, and quite frankly, Your Honor, just had a truly tragic life in a lot of ways. A lot of things have gone wrong for him to bring him to this point, from early childhood into adolescence. He was in the foster care system. He was bullied at school. He had problems at home, and then as a young man, I forget what age, but in around 2002, he was in a catastrophic car accident that's left him unable to do the kind of work he wants to do. And it's been a very hard road. Now, does a hard road excuse criminal behavior ever? No, it doesn't. But again, when the court tries to understand how somebody got to where they are, I think I don't think it's awfully surprising that Jonathan's here today. And frankly, what is surprising is that he's never been sentenced in a court, at least as an adult, up to this point. He's led a pretty good law-abiding life, but through some isolation, through some childhood trauma that he suffered, he became addicted to pornography, and that addiction, much the same way as an opiate addiction can graduate to a heroin addiction, can graduate to a heroin and fentanyl addiction, and then somebody's dead. Well, pornography addiction can increase in severity too, and that's what happened here. And without meaningful work, without meaningful social relationships in a social structure that he could be a part of, again, it's unsurprising that his addiction led him to be before you today, Your Honor. We merely ask that you look at the whole person, that is Jonathan Garfield, and sentence him accordingly. And to that end, Your Honor, we would ask that the court follow the Killebrew agreement. More to the point, we would ask for no more than 12 months in jail. And if the court were inclined to hold any or all of that in abeyance and let him prove himself on probation. Thank you.
All right, thank you. And now your turn, Mr. Garfield. Is there anything you wanted to say?
I would like to say that I really did try to get help in regards to what I was seeing and doing, and I can't say enough that I was misinformed about mandatory reporting, and I was afraid to speak up anymore after that. Since my arrest, I've been made better aware of that. I really wish I would have tried to seek help elsewhere. I knew, in fact, the way I was going about it, it was very risky in the way that I was doing it, and I really just needed it to stop. When the police came, they actually asked me if I wanted to get caught, and it was just, I didn't respond at the time. I was reticent, but I just needed it to end one way or another. I would never harm a child. If I've even so much as indirectly stressed anybody in any way, I can't say enough for what the proper words would be to sound contrite. I don't think there's any words that are available. I'm going to do my best from here on, now that I do have the therapy that I need, and continue with a specialist whenever I can, and try to move on in one way or another. I have tried a lot of different avenues as far as employment and trying to go back to school, but it's a struggle just especially since we moved from the Metro Detroit area, to find a doctor who can understand the compounded case that I'm dealing with. I just hope that's taken into thought, and I'll do whatever is required of me. Thank you for your time.
I'm sorry, I didn't mean to cut you off.
No, I think I think there's really nothing else more to say. I know that it was written that I seemed like I had an attitude problem and that I don't take this seriously. But I take it very seriously, and if I made anybody feel like I wasn't respecting them, I certainly didn't mean to come off that way. All right, that's.
Okay, thank you. Well, Mr. Garfield, I do believe you take it seriously, and I would never say that you don't. Your attorney wrote a sentencing memorandum, and it was fine, but I just think I need to correct some things in it. I know you didn't write it, but I don't want you to have these messages that are, I think, incorrect, okay? So first of all, I disagree with the statement that the victims in this case are unknown, all right? Now, here's just two of them for an example. One is a young girl. She's between the ages of 9 and 12. She's put in front of a camera wearing a lime green bikini top with see-through bottoms. She's got her legs spread apart and she's rubbing in front of her panties. She pulls her panties down and continues to rub her vagina and penetrates it with her finger, licks her finger, and then penetrates her vagina again. A male appears on the screen. She takes his penis and puts it in her mouth, pardon me. Again, she's estimated between 9 and 12 years old. Here's another victim that I can identify, not unknown to me. She's estimated to be between 3 and 18 months old. This little baby is on a camera with her genital area and legs exposed. An erect penis rubs against her vaginal area. She's heard crying. A clear fluid substance is observed sticking to the penis and her genital areas. The rubbing continues, and then the video changes to a scene of her buttocks and a finger touching her vaginal and anal area. And again, this is a baby 3 to 18 months old. These are not unknown victims. They are very well known. I can't give you their names, but they are known. And contrary to what the sentencing memorandum says, justice is not entirely lost on them. Justice is their due. The other thing I have to disagree with, and this relates directly to you, and I'll explain why, but there's a very dismal picture painted in the sentencing memorandum of people who are victimized, as the victims in this case, all then going on to become sex offenders. Well, I'll tell you, I was a prosecutor for 17 years and a judge now for 16 years. And I can say with 100% certainty that sex assault victims don't all turn around and reoffend. Actually, very few of them do. These are not broken people with ruined lives. I see survivors all the time. They rise above it and they don't let themselves be victims. And I think it's important to say this because this notion that people who are victims are destined to reoffend, it plays right into the mindset that people have no choice. And that's where I think it pertains to you because the sentencing memorandum painted you as someone who had no choice and was helpless to change your fate. And you really weren't helpless to change your fate. You had choices. And then the final thing is, the sentencing memorandum talked a lot about your background. And honestly, Mr. Garfield, as bad as this offense is, I have compassion for you. I do. I am so very sorry for the hurt and pain that you have suffered in your life. And I wish that you didn't suffer it. And I wish that you heal. I do wish that for you. But it is not an excuse. And it does not allow you to turn around and victimize other people. And while I would like to see you in therapy for sure, I know that if you're really serious about being in therapy, that you can still do that, and my sentence will not prevent it. And that's why I feel that the appropriate sentence is within the Killebrew agreement, and I will follow that. But you must pay $130 to the Crime Victims Fund, $68 in-state costs. You must register under the Sex Offender Registration Act and comply with the requirements of the act. And you are committed to the custody of the Michigan Department of Corrections for a period not less than 20 months, nor more than 120 months. You do receive credit for 1 day already served. Mr. Garfield, you have the right to file an application for leave to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to assist you. If you're making a request for one, you have to make it within 42 days of today's date. It explains that more on this form that we're giving to you right now. Just know that the time starts running from today's date. And you are remanded to the custody of the sheriff and the Michigan Department of Corrections. Good luck, sir.
Sure.
You take that with you.
He takes that with him.